Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. We have a question here from YouTube user Ellen Smart, who I hope is not using her real name as her YouTube handle, because we have multiple videos telling people not to do that when they ask us questions. However, Ellen asked us, currently, I'm involved with the EEOC. I'm sorry to hear that. I filed a charge against my employer for discrimination, age, sex, and disability. Let me clarify. I'm glad you're standing up for yourself. I'm sorry you have to deal with the EEOC and with this problem, but I applaud you for standing up for yourself. So we have three protected classes: age, gender, disability. My employer wrote a position statement with 2 affidavits attached that are blatant lies. Common. I have a lot of documentation that was submitted with my charge. It is currently in the investigation phase. I will be responding to their position statement. What is the best way to write it? Paragraph form, respond after each statement they wrote with my answer. My last question is, when is the best time to retain an attorney? I was willing to do mediation, but my employer was not. Thank you, L. L is my sister's name. Okay, so I'm gonna answer your questions in reverse. You asked me, when is the best time to retain an attorney? As soon as possible. Ideally before you file with the EEOC, in my opinion, but as soon as possible at this point. Your next question is, what is the best way to write your rebuttal papers, your rebuttal to their position statement? My first answer to that is through your attorney. Have your attorney write it. The next best answer is, and I don't want to be rude to EEOC employees, but if you can write your rebuttal, if you can draft your rebuttal in a way that lets an extraordinarily lazy government employee not have to ever look at another document, that'd be pretty smart. You can do their job for them. It's always to your benefit. So often what we'll do is one of two things. We will either copy each paragraph, each statement from the position statement that we're responding to, and then supply our response following that statement. Or if it's a numbered position statement, which is usually what you get often from the more talented defense firms, we'll go line by line, number by number, and say, in item, in paragraph 14, they said this, this, and this, and it turns out 2 of those 3 things are objectively false, demonstrably false, attached to Exhibit A, Exhibit B, which proves that 2 of those 3 things are empirically, objectively, and demonstrably false, right? Like that's how I would go about it. And you want to make the investigator's life as easy as possible. You also, the clarity of your communication matters, right? Because your ability, if you're representing yourself, your ability to convey the story is on display in your rebuttal in a way that wouldn't be if you had an attorney. And your ability to share your story and communicate effectively is what makes you a dangerous witness. So the more effectively and the more clearly you can communicate, the more terrifying you are to defense counsel. Keep that in mind, right? That is a key thing here and something they are evaluating without question. Ellen, I hope this helps. I wish you the best of luck with your case. I will be cheering for you silently from my little hobby farm in New Hampshire. And I will check the comments of this video to see if you have follow-up comments or questions. If this video was helpful, like, subscribe, comment down below. It helps me to help more people just like you. Remember, almost everybody works. Not everybody wins. Be smart out there, people.